Yeah, so Senate Bill 911 is the Tenant Bill of Rights. This is a pretty dense piece of legislation, but it outlines 6 core rights that all renters in Rhode Island should hopefully have. And just a small point of history, Rhode Island was one of the first states to pass a Landlord-Tenant Act back in 1986, making us one of the most progressive states at the time for tenant legislation. Unfortunately, we have not kept up with that tenant legislation. It was created before me. It was created the same year that Top Gun came out and the same year that Ferris Bueller had a day off, and also the same year that Barbie was created. So it's a little out of date. But one of the things that we can establish is the right to legal counsel in court. Or one of the things, or 6 of the things that are sought to be created with the Tenant Bill of Rights is the right to legal counsel in court, the right to habitability, which we passed in 1970 in Rhode Island, the right to organize, which was passed in 1986, the right of first refusal or the tenant opportunity to purchase, which would be a new right to all Rhode Islanders, the right to equity and freedom from discrimination, which also currently exists in our landlord-tenant handbook, and the right to be free from eviction without good cause. And additionally, it does put in there, prevents rent hikes of more than 4% annually, and also establishes a process for pest mitigation, not limited to bedbugs, ants, cockroaches, termites, fleas, and flies. So why a right to counsel to start off with? On average, only 3% of tenants are represented compared to 81% of landlords in housing court. Even before COVID-19, there were 3.6 million evictions filed a year. Tenants who have been evicted don't just lose their immediate housing, but they face the loss of mental and physical health, sometimes child custody, employment, educational attainment, schools, physical property, and also face an increased risk of homelessness or housing instability just by being evicted. Having an eviction record also, regardless of the outcome, reduces housing opportunities and can remain on a tenant's record for up to 7 years, causing, again, almost a decade's worth of lack of housing and stability. Renters should be able to access the resources that help them avoid evictions, ensure that the legal process during the eviction proceedings are fair, and avoid housing instability. Renters should be able to avoid an eviction filing through alternatives to the eviction system, such as eviction diversion programs, grievance procedures, and prevent formal legal proceedings through negotiations, mediations, and arbitrations. Resolutions to these processes should include a grace period for late rent, ability to preserve tenancy through curing their lease for any violations. So for example, if you have a pet and a no pet unit, it would allow you to rehome your pet and stay in your unit without a violation of the lease or facing eviction. Access to a standard and formal dispute process and litigation, and opportunities to meaningfully participate in pre-eviction diversion programs. The right to habitability, we've talked about it a lot this session. There is also a huge lead problem in our communities. The right to habitability would just ensure that every single Rhode Islander would be able to live in safe, quality, and affordable housing units in our state. I'll skip over to the right to organize. Many folks who live in low quality units that have what many people would deem a slumlord live in substandard units. They have, we just heard downstairs a rally for Homes for All with Reclaim's team, that many people live with mice, mold, and fungus growing inside of their units. And it's not known to them that there are other tenants across multiple cities and perhaps even states that they have folks who have the same property owner living under those similar conditions. Giving the right to organize to without free from retaliation would give an opportunity for tenants to band together and increase their rights and advocacy for their housing. The right of first refusal would provide tenants with the right to negotiate and collectively bargain to purchase their buildings. This would be at fair market price. It would be at the price that anyone on the free market would purchase. It would just allow for folks who've perhaps been living in a building for 5 years, 10 years, to be the first ones to decide if they want to continue call this building their home. TOPA laws and policies level the playing field, especially in a highly speculative market, and especially in a market like we're seeing now, where there is low housing stock and a huge demand for rental units right here. It also increases the affordability of housing for renters, stabilizes neighborhoods and communities, and keeps people in place. The tenant opportunity to purchase is an emerging set of anti-displacement policies and tools that can be used to permanently preserve affordable housing stock and remove land from the speculative market. These policies put current renters and community-based organizations first in line to make an offer on a property when it goes to sale. There are several other communities that have had tenant opportunity to purchase legislation, including DC, which has had this sort of legislation for about 25 to 30 years. Freedom from discrimination. No one should face discrimination when when seeking housing or when involved in the housing process. And then the last one, the right to be free from eviction without good cause. Eviction without good cause would prevent folks from having their tenancy terminated, except in cases of lease violation, like failure to pay rent or other infractions. It would also allow families to stay in communities close to schools, where they work, and other things that fit their lifestyles. It also prevents rate hikes of more than 4% annually, which essentially acts as an eviction for most families. And this bill also gives landlords room to increase if they show that their costs have gone up or if they've made improvements. I think this is a win-win for both tenants and landlords, because it, again, allows for a room for increases if there have been substantial changes or improvements to a rental unit. And that is the Tenant Bill of Rights.